Good day, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk. It's Saturday, so what does that mean? That's right. It's time for the weekly recap of the top stories throughout the week. Hope you enjoy it. Have a wonderful weekend, and have a wonderful 4th of July holiday. More information on the Murdaugh family case in South Carolina. This case, for some reason, I just think it is so interesting. When you have a kid, Paul Murdaugh, who was basically under indictment for the death of a young lady who had her whole world ahead of her. There's power, influence, maybe some corruption that slows the investigation because the family's politically connected. And then Paul Murdaugh and his mother, Maggie Murdaugh, are found at their hunting lodge in South Carolina by the father. No real leads, but another case is reopened as a result of information found at the house. Now, apparently there were several vehicles at this little hunting lodge that the Murdaughs had, but the police have recently towed a black SUV from the residence. It is reported that the Colleton County Sheriff's Office asked a tow truck operator to come to the Murdaugh property and tow away a black Chevrolet Suburban. The owner of the towing company told the local newspaper that the driver, who was wearing gloves, drove the Suburban onto the tow truck and then was escorted by multiple police units to the sheriff's impound lot. According to the driver, he did not report anything to his boss, that he did not notice any bullet holes or blood in the SUV. It's not exactly clear why that particular vehicle was seized and how, if it may be linked to the killings. It's unclear. As stated, there were many vehicles there at the property, but only that one seems to have been seized for collection of evidence, or the police think there is something of evidentiary value in that car. Now, the family is offering a $100,000 reward leading to the information that results in the arrest of the killer. If anyone has any information, they should call the South Carolina Law Enforcement Division, also known as SLED, at 803-896-2605. And like I said, the reason why I think this is so interesting is that you have this Murdaugh family which has deep roots in South Carolina, the legal community. Multiple generations of family members have served as the local prosecutor for some 87 years. You have to wonder if maybe someone wasn't happy, and maybe it had nothing to do with the case where the young Paul Murdaugh was under indictment. And for those of you who do not know the circumstances regarding why Paul Murdaugh was under indictment, let me give you a quick summary of those facts. So Paul Murdaugh was indicted in April and charged with boating under the influence and causing the death, and 2 counts of boating under the influence causing great bodily injury. He had pled not guilty. The matter was set for trial. Ultimately, those charges were dismissed based upon his passing. Victim who passed away in that case was a woman by the name of Mallory Beach, a very young woman. She was 19. And she was thrown from the boat when it crashed into a bridge piling on the early morning hours of February 24th of 2019. It was a week later until they found her body. Now, this was down in Beaufort, South Carolina area, and the body was found near Parris Island. I happen to be stationed near Parris Island. And if anyone has seen the Low Country, the tides come in, the tides go out. And when the tides go out, you're left with a bunch of mucky mud, and it's thick, and the currents can be rather strong and suck people and things in and out as the currents flow. There was also a civil case that was filed in the wrongful death suit against a Beaufort County bar and a convenience store, as well as 2 homeowners who allegedly served the 6 underage drinkers alcohol that night. The suit was also alleged to name Paul Murdaugh's father and his brother. The civil matter has gone to mediation, but there's been no resolution. Now, Anthony Cook, one of the kids that was there that night, he stated in his deposition that the 6 friends attended an oyster roast out on an island on February 23rd of 2019. They traveled there by boat. Adults at the party asked the group not to take the boat back because of foggy conditions. Paul Murdaugh, however, insisted on driving the boat back, and the group left around midnight. According to Cook's deposition, one of the group offered to call an Uber for the group, knowing that Paul was drunk. But the rest of the group refused, choosing to ride back with the intoxicated Murdaugh. The group argued over stopping for one last drink after the oyster roast. 2 wanted to stop, Murdaugh and another kid. Eventually, they won the argument. The group stopped off at this bar in Beaufort, South Carolina, where Murdaugh and his friend went into the bar while the other 4 waited. When they returned, the group continued to argue. Apparently, Murdaugh got behind the wheel of the boat, pushed the boat full throttle, ultimately resulting in the boat hitting the bridge pylon, throwing Miss Beach from the vehicle. So hopefully there's a little background information regarding the underlying case and why a lot of people were upset with the young Mr. Murdaugh. Mark Means, I'm telling you, I should be sending this guy a mug. He always helps provide content. We know because Mark Means filed a motion to compel, basically saying, hey, I haven't been turned over any discovery yet in the homicide case, and I want it. Now he has filed a supplemental motion to support his motion to compel, detailing how he drove from his office to pick up the discovery at the district attorney's office, only to be told that they'll turn it over on a disc at their own time, and that they will also be filing a motion in July in response to their motion to compel. And therefore, he made the basically 5-hour trip, round trip, I guess, and then he wants to be compensated for his time. A couple of things about this. We'll go through the motion really quickly, but he's basically billing for his hourly rate, but he has to remember now he's being paid by the state, and I've never seen a state rate equal that of your private hourly rate. Usually it's rather significantly reduced. So let's go through the motion rather quickly. Mr. Mean complains that he was given the opportunity, or in the government's responses, to come and inspect the evidence. Yeah, that's the standard response, but let's face it, everybody knows you're going to get the discovery, whether it be on a hard drive, hard disk, or some sort of digital form, or ultimately a paper copy. Obviously, with large discovery, most people these days prefer, particularly the prosecutor's office, turning it over in a digital format because it saves money. Well, needless to say, Mr. Means apparently got up on June 21st, having not received any email, phone call, or the like, that this notice was not adequate. He apparently had sent them an email stating that he was going to come and check out the discovery. So he awoke at 4 a.m., traveled to Fremont to ensure that he was timely, arrived approximately 10 a.m., spoke with the receptionist. She then contacted prosecuting attorney Blake, and Blake ultimately responded, stating that they were going to file their responses and that they will turn over a hard drive. Apparently, Mr. Means had turned over a hard drive that he had just purchased, wanting the discovery. Well, needless to say, Mr. Means didn't get any discovery, went home, and then filed his motion to compel. Now he is asking to be compensated. As a result of the discovery request notice above, my notice, failure of any communications by the prosecuting office, my office incurred 11.5 hours at $325 an hour for legal fees, minus 2 hours to meet with client, which was not going to happen if production by prosecution had occurred. He had driven 728 miles, charging the government rate of 58 cents per mile, as well as the drive to get the hard drive. So that's $186 for his mileage, plus the fees. He is charging and wants to have the government reimburse him $4,346.06. Basically stating that if the state had complied with the rules, that this never would have happened, and therefore he wants justice. Okay, certainly the prosecution has an obligation to turn over discovery. As a defense attorney, when you charge a case, you, as the state, are saying, I am ready to go, and here is the discovery. So yes, I do understand Mark Means' frustration with having the discovery turned over. Any defense attorney has run into this. However, the mere fact that you didn't get the discovery, and the prosecutor is stating that when the prosecutors are saying that everything has been turned over previously to you, other than maybe a few matters related to the homicide case, i.e. the Tammy Daybell autopsy, that should be produced. I get it. But the prosecution is going to say, we've already turned this over to you. The case has been stayed. Now, certainly the defense can get up to speed on the case, but I have never seen, never, ever, ever have I seen a judge hold the state basically in contempt and make them be awarded attorney's fees to the defense counsel. It's just not happening. Now, where does this kind of stuff take place? In the civil world. Where does Mark Means come from? In the civil world. Welcome to the criminal world. Mr. Means, I will be shocked, and I will send you a Crime Talk mug if the judge awards you $4,346.06 as my way of saying I was wrong, but I don't think that I am in this particular case. But hey, you keep up the fight there, Mr. Means, because you provide great content. Thank you so much. Bill Cosby is going home, a free and innocent man. Okay, hate to say that I called it, but I called it. What was the big issue in that particular case? There were two really on appeal. First, Cosby claimed that he had a deal for basically a non-prosecution of any further incidents. That district attorney at the time cut the deal. The court said that deal is binding on the district attorney. But wait, there's more. The most significant thing, and I brought this up at the time, and you can go back and look at the video, and I called it 404B evidence, right? The evidence of other misconduct, not to show bad character evidence, but to show a pattern of conduct. There were witnesses who testified as to Bill Cosby's mistreatment of women going back to the 80s, okay? 404B evidence has to be very narrowly tailored, and it has to be very limited. Otherwise, it turns into a bad character fest. And guess what? It's prejudicial. But I assure you, as a criminal defense attorney, I am not a big fan of 404B evidence. It has to be very limited and narrowly tailored for it to come in. More cases get reversed on 404B evidence when it simply was not relevant, and it is considered to be propensity evidence, right? Propensity evidence is evidence to show we believe that the defendant is a bad guy. Look at all these things that he's done in the past. He's a bad man. That is strictly prohibited under the rules, except for a very narrowly tailored exceptions to show motive, modus operandi, absence of mistake. But if it's simply there to show bad character evidence, it's impermissible, unfair trial, and in this particular case, it may get Mr. Cosby a new trial. What did the Pennsylvania Supreme Court say? That the bad character evidence, the 404B evidence, overwhelmingly turned into bad character evidence, and therefore, case reversed, statute of limitations has run, deal with the prosecutor done. You can't recharge Mr. Cosby. He's going home. Now, let's be clear. Do I think Mr. Cosby did all these terrible things? Yeah, I do. I think it's rather convincing that he used his position to get these women to his room or wherever they engaged in activities, and he probably roofied these ladies or used the equivalent of roofies at the time. But he's also protected under the law, and you can't just change the law to get somebody that you no longer like. You have to go based upon the law. Now, this is why appellate courts are so important. The trial courts have to deal with the emotion. They have victims sitting in the courtroom. They have family members sitting in the courtroom. They don't want to be perceived as being the mean bad guy at the trial court level. But they still have a duty to do their job. All right? Their job is to look at the facts, apply the law, let the chips fall where they may. This is what happens. It goes up to the appellate courts. The appellate courts look at a cold, hard record, and they just get to read it. They're not in the courtroom. They don't have to deal with the emotions of it. And they say, you misapplied the law. And why? They do what the law shouldn't allow. And they allow emotion to come into the process. The law should be devoid of passion or prejudice. That's why it's supposed to be look at the facts, look at the law, apply the law. That's it. Anyway, Bill Cosby going home, district attorney in this particular case, and the court looks like they completely overstepped based upon the opinion, what we've seen thus far. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. And we basically said, hey, if you go back and look at our old videos, we thought this may be an issue. Well, the Pennsylvania Supreme Court cited an oral agreement between the prosecutor early on in the Bill Cosby case, stating that there was a non-prosecution agreement. There was even a hearing held regarding what was said, who said it, when. Although it wasn't memorialized, the then district attorney, Bruce Castor Jr., stated that, hey, we told everybody, we had a press conference. Everybody knew that this is what was taking place. We were not going to prosecute Bill Cosby because we had concerns about the witness's credibility, the strength of the evidence in that particular case. But he said, hey, we won't prosecute. Bill Cosby can be deposed, and then the civil case will go forward. Not sure why district attorneys are getting involved in that, but apparently he thought that there was some benefit at the time. Then 10 years later, new district attorney comes in and says, I wasn't bound to any of those agreements. Nope. Well, the Pennsylvania Supreme Court said, yes, you are. And the court described what the prosecutors did in this particular case as a bait and switch, basically telling Mr. Cosby, you have immunity in that deposition. It won't be used against you. And then they said, oh, sorry, now that we got all this good information, no, you don't. That's a bait and switch. And it carries over from one prosecutor to another. And what can I tell you about this as it relates to real life? Well, your word matters, okay? If you are a prosecutor, if you are a defense attorney, your word matters. If you say you're going to do something and this is what the deal is, then that's what the deal is. And you better memorialize it so that somebody else who picks up that case file down the road knows what the agreement is. Now, I'm not saying that Bill Cosby is a great guy or even that he is innocent. He clearly put himself in some very compromising situations, but the rule of law needs to apply to everybody, and it cannot be politically motivated. As you may recall, this all kind of took place at the height of the Me Too movement. That's a great movement, okay? But you can't substitute the law for your emotions. We've talked about this repeatedly. The other thing that the court was concerned about in the Bill Cosby matter was the 404B evidence. We've talked about 404B evidence all the time. I'm telling you, 404B evidence was drafted the rules of evidence were drafted so that you can get into stuff when basically the prosecutor's case sucks, okay? And I'm telling you this from a defense attorney perspective. Yes, you can consider that for whatever purposes, but I'm telling you, if a prosecutor's case was so strong and so overwhelming, they wouldn't need to bring in 404B evidence. And why is that? Because 404A of the rules of evidence clearly states that you can't bring in bad character evidence, okay? Each and every defendant has a right to be charged on the crime charged, not what he did 10, 15, 20 months, 20 years ago. It's based upon what he did here. The defendant may be guilty of all those other things, but to bring that in and say, well, he did it before, he must have done this particular allegation, that is what they refer to as propensity evidence. Think about it, ladies and gentlemen. It just defies fundamental fairness. And if the prosecutor had a strong case, they wouldn't have to come in and say, well, Judge, it's not propensity evidence. We're just going to toe the line and we're going to say it's for identity purposes. Yeah, that's it. Or absence of mistake. Oh, yeah, maybe that one too. The legal standard has become on 404B evidence, and I think it's starting to change, not only in this Pennsylvania decision, but other decisions I've seen, because it crosses the line and it clouds giving somebody a fair trial. When you have people talking about what you did 20 years ago, has nothing to do with what you did that particular day. So if you hear of a prosecutor saying, we have 404B evidence, the one thing that should come to your mind is the prosecutor's case sucks. If they didn't need 404B evidence because their case was great, they wouldn't bring it in, right? 404B evidence is certainly there for impeachment purposes. If a defendant got up and said, I'm absolutely innocent, I've never done anything like this before in my life, bam, then you get to bring it in. But you don't get to bring it in until the defense raises the issue by saying, I'm a great guy, never done it before. So that's where it is on 404B evidence. Now, how does this relate to other cases that are going on out there? Well, remember Ghislaine Maxwell? She had that guy named Jeff who pled guilty when he was looking at a federal case, and then he pled guilty in state court to some solicitation charges. He had a non-prosecution agreement by his plea agreement saying that neither he nor anyone associated with him, whether named or unnamed, would be charged in federal court. Now, we'll see what the court does with those motions for Ghislaine Maxwell, but I think you maybe even have a stronger case for Ghislaine Maxwell than you did for Bill Cosby, because it was actually memorialized for Ghislaine Maxwell. And there's also information to suggest that the then United States attorney that cut that deal, Mr. Acosta, sent that agreement all the way up to the then Attorney General to give its stamp of approval. So how would the Southern District of New York not be bound by an agreement by the United States Attorney in Miami when it's been approved by the main man at justice? We'll see how that shakes out. Now, another case where this similar type of situation may shake out is, that's right, that guy named Harvey. Remember, he's in New York, had a bunch of allegations. Then they had a bunch of 404B evidence brought in from people that weren't charged. That's right. They used it to try to show modus operandi under 404B. The defense objected. The court allows it in, gets a conviction. It's going to have to go up on appeal. And like we've discussed in the past, the good thing about appeals are the appellate court only gets the cold, hard record. That's it. No emotion, no drama in the courtroom, nothing. Nothing where the judge is trying to appease everybody and split the baby in the courtroom to make sure that everybody either feels somewhat satisfied. That's not the way the law has ever been done, and it's never the way the law should be. And that's why you have appellate courts, because, as always, the law should be removed from the emotion of the fight, the battle, so to speak. apply the law to the facts. I once heard now deceased Supreme Court Justice Antonin Scalia, and he said, if you are a good judge, you don't always get the result you want. And if you always get the result you want, you're a bad judge because you're making decisions, you're making conclusions and figuring out how to get to that decision. And the example he gives is I believe it's called the McKinley case, which is the flag burning case where they said it was protected speech to burn the United States flag. And Justice Scalia said, hey, I'm offended by people burning the United States flag. However, that is the epitome of free speech, political speech, and we are not and should not criminalize it. He personally was offended by it, but he said we had to apply the law to the facts. That's it. He didn't like the decision, but that's what the law required him to get to. I wish more judges applied that theory and actually did it the correct way. What other country in the world could you be this bizarre and not be apprehended a heck of a lot sooner? Well, only here in America, ladies and gentlemen. Only here in America. All right, the affidavit for the arrest warrant for Lori Vallow in regards to her case in Maricopa County, Arizona, for the conspiracy to commit the death of her husband number 4, Charles Vallow, with the aid of her brother Alex Cox, has been released. And boy, we all knew it was bizarre. Just further confirmation that Lori Vallow has some real issues. I guess my question is that Charles Vallow petitioned to have Lori Vallow comped, and it really never went anyway. She was released rather quickly. But Charles Vallow said, she thinks that I am possessed and I go by this name of Ned and a dark person. And then we have text messages back and forth between Alex and Lori Vallow, basically stating that, well, for lack of a better term, he has dark energy and he needs to go. Well, when Alex Cox was at the Charles Vallow residence on June 11th of 2019, the call to 911 dispatchers told authority that he had just killed his brother-in-law in self-defense. Now, the police were a little skeptical at first because of issues, but, basically there was no rush in the investigation, apparently. The police also felt that they didn't have probable cause at the time to arrest Alex Cox, and certainly not Lori Vallow at that time. But as things progressed, the investigation continued, and it was discovered that the Charles Vallow had this concern because Lori Vallow kept stating that she was selected to prepare 144,000 people for the end of the world. Now, like I said, he petitioned to ask for a mental health evaluation, and in that petition, Charles Vallow says that Lori thinks that he's possessed by a dark spirit by the name of Ned Schneider. Lori would even refer to Charles Vallow in conversations and documents by the name of Ned. Now, during the time of the investigation, obviously we all know that the kids, Tylee and JJ, disappeared. Charles Vallow's deceased. And during this time, investigators learned that Lori Vallow had married Chad Daybell. Oh, and by the way, his wife had just mysteriously died as well in her sleep. And then the two of them got married rather quickly. Now, Charles Vallow obviously was aware of Chad Daybell and was going to actually go to Tammy Daybell and let them know of this extramarital affair between Chad Daybell and Lori Vallow. And to make a very long story short, as adultive data recovered from cell phones as well as from the iCloud storage system, it was believed that none of the mentioned crimes were simply coincidence or justifiable. Specifically, the police alleged that the evidence shows that Charles Vallow's death was planned and necessary somehow in the eyes of Lori Vallow to prevent Charles and others from confronting Lori about her extreme religious beliefs when he came back into town, into Arizona, on July 11th of 2019. The police also state that the death of Charles Vallow was also necessary in order for Chad Daybell and Lori Vallow to marry and fulfill their religious prophecy. We've heard this before, but the police put it in their affidavit that Lori believed that she was an exalted goddess and that she and Chad, like I said, were going to lead these 144,000 people into preparing for the end of the world. A lot of people came forward to talk about this cult's belief system and provided insights as it relates to Chad and Lori's beliefs. It also apparently became quite clear to people that had talked to the police that Lori and Chad believed that they had these extraordinary abilities, which included the power to teleport and cause harm to others. They also had the ability to call upon natural disasters, the ability to pray away demonic spirits attached to others, and also visionary capabilities. And because they had these extraordinary abilities, they were able to tell whether somebody was light or dark, basically good or bad, and whether they should die and were going to interfere with their religious plans. Now, a couple things come to mind when I read this affidavit. First, clearly bizarre stuff. However, here in America, just because you believe in bizarre stuff doesn't mean that it's a crime. But obviously, if you harm people, it is then a crime. But just to believe what most people would be considered crazy doesn't necessarily make you a criminal, doesn't necessarily make you insane. For example, we have lots of people that believe in the world that the world is flat. Now, maybe that's what they truly believe. Maybe they're crazy. Maybe they're just very gullible to believe such a thing, when you could probably prove it rather easily that most of the people in the world and evidence would show that the world is in fact round. So the fact that Lori Vallow and Chad Daybell had these beliefs in and of themselves, like I said, isn't a crime. But clearly, if you go around killing people, it becomes a crime. And having done cases that involved where people refer to it as a cult, you usually find that there was a couple of people that had some very devout beliefs, and they followed those, but they weren't going to harm anybody. And then these people all get together, and they just feed upon each other, and then they start thinking that they have visions and they are the prophets, and they can see when the end of the world is coming, and they just feed on themselves. It's one of the more bizarre situations I've ever had to come in contact with. But there's usually someone that just takes it a little too far because they start believing truly that this is taking place, that the end of the world is coming, or that they in fact do have powers that clearly they don't have. I would be curious as to why neither Chad nor Lori have created some sort of natural disaster so that they could break free from custody, or use their teleports to escape as well. Their deadline for the end of the earth has come and gone. So clearly, one would maybe think that their beliefs are wrong, but they will always find a way to rationalize it, which basically means it's delusional. So what happens when you have a bunch of delusional people get together talking about crazy beliefs? Well, you get a lot of crazy people starting to do a lot of crazy things. The next thing that is concerning to me is that a lot of people were aware of this belief system, and I'm curious as to why it took a year for Mark Means not to have an evaluation done almost immediately. I would also want to know if whether Mr. John Pryor has comped Chad Daybell as it relates to his beliefs. If he truly believes that he has some powers, then he really may not be competent. He may be able to hold a conversation, but if you are having delusional ideations and believe that you have these powers, you may have mental health issues for sure. All I can say is this thing is getting more bizarre as things go along. It's a little sad that the police authorities had to take so long to get to where they are, and it looks like the real perpetrator, the one who actually probably did the harm to everybody, Alex Cox, is now deceased. Of course, the next question that begs to be answered is, could it have been Lori and Chad? The coroner says no, but so did the police. Originally determined that Alex Cox was justifiable in killing Charles Vallow. So things are not always as they seem. And what happens when the truth turns out to be a big lie? Let me know what you think about the Vallows. I think it will be years until Lori Vallow is restored to competency, if ever. It's certainly not going to be within the 90 days. Or do you think she's just making this whole stuff up and she was just playing on this whole goddess thing so that she could get people to do what she wanted? Let me know. Have a wonderful 4th of July weekend. Remember, those founding fathers, the Revolutionary War, they were true patriots. They were rebels. Go enjoy a little freedom this weekend and put that flag out. Have a great weekend. We'll see you next time on Crime Talk.